of 160 Eastern Avenue by the used car dealer at the time, Malden Auto Brokers. That dealer's office was located across the street, and there was parking across the street. I think it's 225 Eastern Avenue, which was, there for his vehicular stock for his business. And 160 Eastern Avenue was just overflow parking or storage of his vehicular stock. Beginning in 2018, and when the current occupant, AGM Motors, took over that space, the licenses issued by the committee had dropped the restriction prohibiting 160 Eastern Avenue as the actual business location for the Class 2 dealer and allowed that to be it. And what has happened here, quite frankly, is being unmindful of the technicalities and formalities of zoning and special permits. Neither the Class 2 dealer who's the tenant, nor my client, Mr. Gottschalk, as the trustee of the owner trust, realized or understood that just because the Class 2 license that was issued to the dealership allowed it to be the actual business location of the auto dealership doesn't mean that it's authorized by virtue of the special permit that applies to the property. And in fact, that use is not authorized by the current special permit. All that is permitted there is the overflow parking from the business which used to be located technically across the street. So we now need, I want to assure the board that this does not represent an instance where anybody was looking to pull one over on the board. What it represents is a failure of a couple of laymen, quite frankly, to understand, again, the technicalities and legalities of the special permit process. Certainly the license committee is empowered to grant licenses to Class 2 dealers, but a Class 2 dealership license issued by the license committee cannot supersede or override a special permit that applies to the property if it prohibits that use. And that's the situation we have here, and that's the situation that's been in place for about the last 5 years at this point. It came to the attention, I was informed by Commissioner Miller that how this matter finally came to the attention of the city was the compliance division of the inspectional services noticed the signage on front of the building and knew that that particular signage had not been through the SDRC approval process. And once that cat was out of the bag, so to speak, it then became known to the city, inspectional services, and the planning board that the special permit in place on the property didn't actually authorize this particular use, notwithstanding the fact that the license committee had been granting licenses, again, for about 5 years that did allow the business to operate out of that space. So in order to correct these various errors that have occurred and been in play for about 5 years now, the remedy was to come before the planning board and seek an amendment to the special permit that would allow the actual operation of the dealership business at 160 Eastern Avenue. And again, that's why we're here. The property is and has been used by 2 occupants, one of whom is the Class 2 dealer for about the last 5 years. The other is the petitioner and owner, Mr. Gottschalk. He operates his landscaping business out of the northern section of the building, and the northern section of the lot is dedicated to that, with the small southern portion of the building and about half of the lot, southern section of the lot, being dedicated to the used car dealership at this point in time. Let's see. This property is located in the central business district at this point in time. The use that is being requested by virtue of this special permit application, that of a Class 2 dealership, used car dealership, is allowed by right in the central business zoning district. If this individual, if this restriction in the existing special permit didn't exist, this individual could have occupied this property without issue as a used car dealer, but because the zoning is permitted in that area. With respect to parking, again, the central business district places no parking requirements whatsoever on uses allowed by right in the district, and as a consequence, the use that we're requesting be legalized by this petition does not need additional parking, and the existing parking on site does not violate or exacerbate parking deficiencies, because in a central business zoning district, there are none as a practical matter. In addition, the actual physical use of the 1,200 square feet within the interior of the building does not create any new dimensional control violations of any kind, does not exacerbate any dimensional control violations that may currently exist. There are dimensional control violations to the property, all of which were legalized by virtue of the previous special permit granted in 2016. So we appear before the board tonight seeking corrective measures and corrective relief from the board for a use that should not have been allowed or should not have occurred. We admit that, because it's not allowed by the existing special permit. But as I said earlier, one of our objectives is to assure the board that, again, this was not done out of intentional disregard for the requirements of zoning or special permit. It really was an honest mistake by two laymen about what the Class 2 license that was issued beginning in 2018 and right up through the present that says it's okay to operate the business from that location. Operating the business from that location does not create or exacerbate dimensional control violations. It does not create or exacerbate parking deficiencies or requirements related to that use as a practical matter. And I think the biggest issue for purposes of the legal standard, that being, is it more detrimental to the neighborhood? Oftentimes the board is asked to engage in speculation, take out a crystal ball and try to figure out if a proposed use, how it's going to impact the surrounding area, and if that impact will be detrimental in any way, shape, manner, or form. This is a somewhat unique situation because you don't have to engage in speculation about what this use will entail for that area. It's been in place now for 5 years at this point in time. What the used car dealership does at that location is a known factor. It's not an unknown, it's a known factor. It's been there 5 years. We would suggest that it has not created any problems, issues with parking, traffic, or anything else that causes this use to be more detrimental to that surrounding area. If so, I think that would have come to the attention of the board or other municipal officials a long time ago. 5 years is a long time to be running a business without any stated problems. We're not aware, at least, of anyone who is complaining about the use of that property at this point in time or suggesting that that use is creating unacceptable conditions in the surrounding area. So we're asking the board to act favorably on this petition. As I said, it's corrective in nature. It's a problem that was created inadvertently and innocuously by the parties involved. But as a practical matter, it's a technical problem, not a practical problem. The technical problem being it's not technically authorized by the special permit at this point in time, but it doesn't create practical issues or concerns for the surrounding area. My client, Mr. Gottschalk, is here, and both he and I are more than happy to address any questions or concerns the board may have regarding the petition. In addition, counsel for the tenant, AGM Auto, and the owner, operator, and principal of that business are also here. I've been asked by counsel for the occupant if he could, after I finish, make a presentation to the board on behalf of the petition and his client. I don't know how the board might want to handle it. If there are questions, if they want to address them to me and Mr. Gottschalk first, and then have the tenant and his counsel.
Yes, I would prefer to do that because, sure. I mean, this is the presentation for this petition. Mm-hmm. Unless you're telling me he's co-counsel with you.
He's not co-counsel on the petition.
Okay, then I'd like to hear from you and speak with Mr. Gottschalk. Sure. Because I actually do have a few questions. Yep. We've had miscommunications with Mr. Gottschalk in the past where he's done things that he wasn't allowed to do or permitted to do because he said he didn't understand. So this has happened in the past. So I understand what you're saying, that the city council has awarded them licenses, but as the owner, he should have known that he wasn't allowed to do that, that was supposed to be just an open-air parking lot. I went by there several times, and it's chaos down there, not only at this property, but in that whole stretch, that whole block. People parking in the bus stops, people not respecting the one-way in and exit through Ferry Street that they're pulling back out onto Eastern Avenue. When I went down there most recently, there were 24 line spots, and they had 27 vehicles fit in there. Now, is that what you're referring to, that they don't have any parking requirements, even as it relates to the number of vehicles that they have on site?
No, they're certainly bound by whatever is authorized either by the special permit in place or that may be in place after this evening as amended, and perhaps more importantly in that respect by the city council license that they've been granted. We acknowledge that the current parking layout is not what is proposed. I think if the board were to look at the new plan, you see a very detailed parking plan, and it's designed to, and there will be restriping necessary as a consequence of that. And our position is that we would correct any issues with respect to the number of cars there by virtue of this process, basically.
Because they're not using it the way the plan was approved back in 2016.
Well, that's true because well, most importantly, because it's just supposed to be overflow storage of vehicular stock on site, and it's being operated now as the actual business location and has been for a number of years at this point in time. But again, as this petition, for purposes of this petition, this parking plan has been submitted, and that's why we refer to it as a site lease plan. These are the spaces that are being leased and the parking layout that is part of the lease going forward. And we would represent to the board that parking will be compliant with the plan as submitted to the board with this petition to amend the special permit.
Okay, now, do they have any parking inside the building?
No.
So I saw several cars parked blocking the garage doors that had AGM license, that license rim around it. And it's posted, so I give Mr. Gottschalk credit for that. He's got it posted, don't block the doors. But when I was there the last time, there were 3 cars blocking the doors that appeared to be associated with the lot. So that would bring the number of cars up to 30 associated with the service.
Well, again, Chairman, I would say that if the special permit is amended by favorable action by the board, there'll be a new parking layout based on that plan, and I'll represent to the board to the extent that my client, the petitioner, is the owner of the property and in control of it in his capacity as landlord, that he would be expected to and required to enforce the parking, whatever parking is called for on that plan and approved by this board if it acts that way. I could ask Mr. Gott, I can't speak to that particular issue, Chairman, of on whatever day you visited, there being some cars parked in front of doors blocking access to those portions of the building. Perhaps Mr. Gottschalk can offer a little bit of insight on that.
Okay, the last time was today when I was there, but I had been there previously also.
Hi, my name is Richard Gottschalk. I own the property at 160 Easton Ave.
And you're residential, you live at 160
No,
Easton Ave?
I don't. 7 Nelson Way, Wilmington, Massachusetts.
Thank you.
As far as the parking on the outside, that's the car dealer. And blocking the doors has nothing to do with our side of the business.
Right, for the landscaping.
Correct.
But you are the owner, and you are responsible for your tenants, correct?
I guess so, yes.
You guess so.
Yeah.
You are. You know, so you should, if you see this going on when you're going in to do your landscaping stuff, you need to talk with your tenants on this.
I'll make sure that happens.
Okay. Can you speak to the, traffic pattern? When
We
did that happen?
We actually put that in.
Yeah, but,
Because-
so that wasn't part of, because I looked at the decision from 2016.
Yeah, no, that
and that wasn't part of it.
No.
So it makes me question whether we're in compliance with the 2016 permit with regard to the use of 160 for car sales, for the traffic pattern pushing it out, and then seeing today that they're not, people aren't adhering to it. They're pulling back into the incoming traffic and then making the left or right on Easton Avenue.
I mean, that was put in because of the market next door, because they were all doing that anyways, you know, going down Phillips Court and hanging a left down at the end and ending up on the other side of the tracks.
Yeah, and I don't know where it was. I know when I was trying to pull in, 3 cars were trying to squeeze past me to get out on Easton Avenue.
The U-Haul has that, you know, U-Haul's next door, so their people pulled down the wrong way. We, you know, and other people pulled down the wrong way.
Yeah, I don't know where they came from. I just
Yeah, I
know
don't
that
know
they were
either.
coming out through the indoor.
Yeah.
Okay, is there anything else that you can, I mean, I struggle about the fact that there was a miscommunication, because when you were here in 2016, at the end of it, there was a miscommunication at that point too, and I asked you if you understood what the permit was and what your responsibility was at that, at which you assured me you would adhere to it.
Yes, and actually, what happened was is that when we came to the meeting in 2016, we hadn't constructed the building yet. So that's why we had to have that off-street parking, because there was no office space. There's been a car lot there since I was in high school. And across the street was the office. And then they said that because the office was not on the property, they couldn't give the car dealer an office on the property. There was no building. So when that all took place, I thought that, you know, myself, I thought that once the office went in, that would correct the problem on the special permit. But I didn't realize that the special permit supersedes regular zoning. And I thought that, you know, I looked it up and I said, oh, geez, yeah, so the car lot can go there, the office is there. You know, I thought I was complying with everything.
Okay. Is there anything else you'd like to add? Let me see if there's anyone else has any other questions. Eric McCush.
Thank you, Mr. Chairman.
Oh, sorry, I did that again. Oh, there we go.
I'm just wondering, where's the snow storage on the lot? I might not be seeing it, but I don't see it.
Yeah, it's down in the back right-hand corner. We call where the bins are. It's got a
Okay.
kind of a wavy line.
Okay, thank you.
And there isn't a fence preventing you from
There's a fence
getting
there,
there?
but there's two open gates.
Oh, you can go through and
Yeah.
open the gates, okay. 'Cause
Yeah,
there's
that's
our
where we
fence
put our,
there.
that's where the landscape company puts their mulch and loom or whatever. So in the wintertime, there's nothing there, so that's where we can put the
Right.
snow.
Because that was another disconnect between the approved plan from 2016, was there were metal containers that were supposed to be along that side, and I didn't see any metal containers today or the last time I was there, nor do I see them on the plan.
There are no metal containers on that property. The property where the salt is on the bottom is the MBTA property.
Okay, no, because on the approved 2016 plan, there were metal
Yeah,
containers.
and we took everything out.
Okay. Michelle, you had a question?
Yes, I did. Thank you. My question has to do with just asking for some more information, because we did receive the records that were on file with the city council and city clerk and with the building commissioner. And the records indicate that since 2018, so 2018, 2019, and 2020, the car license, the car dealer's license was issued to you.
Actually,
It
it
says
was my
it-
family, yeah.
Yeah, so it says Gary Goschalk doing business as Gary's Auto Sales. So
Correct.
you ran the auto sales business for 3 years on your own property.
Up
It
in-
wasn't that somebody
Well, no,
else.
We were starting to, that was our intention. We never really got it off the ground. And once COVID hit, then, you know, we decided that we weren't gonna do it. And that's when Marcos, who was the tenant, he was renting the front space from us. And that's when we, you know, decided that we would go into negotiations with him to rent the office and the front space.
But for 3 years, the license was in your name, so you renewed the license every year for 3 years, as if you were running a car dealer business.
I don't
So-
remember if we did it every year, but we.
Yeah, we have the
could've.
licenses, so
Yeah,
I'm
we could've.
curious, how is it that you're stating that you didn't know and the new person didn't know when it was you? Could you give any more information about that? Because that 2018 was, you know, right after you were before this board, so can you give any more information as to why you didn't know that, or?
Well, the reason is because before the building was finished, which we finished in 2018, is when the office went in that we could do something with that car lot. Other than that, we couldn't do anything with the car lot unless we built an office. And that's what we ended up doing. So when we put up the building, you know, I thought it was by right because of the fact that there's an office there now. We had the 18 parking spaces, and, you know, that's what I rented.
Yeah, no, I guess maybe I'm not being clear. So in 2016, the board had the license, and it was part of your presentation that you knew that could only be used for display of cars by
At
the
that-
guy across the street. So you came to the hearing and you knew that in 2016. So
Correct.
how then, the next year, did you think you could do something different? I'm not understanding
Because
what
we-
changed.
Because there was no building there in 2016. So we erected the building and we finished the building in 2018. So that's what made it a place for an office, which, you know, I didn't realize with the special permit that we weren't allowed to do anything by right because of the special permit.
Okay, but then on the plan that the board approved, you said they would be your offices and only your offices. They were gonna be the landscaping contractor's offices, so that, you didn't remember that, or what?
Yeah, no,
What
that-
happened there?
yeah, we put the office
Because the
there.
offices, when you came and showed the offices.
Right.
You said they were gonna be for your business, so I'm just curious what happened.
Once
Yeah.
we put up the building, we decided that we were gonna, you know, try to get into the car business ourselves. And we decided that it wasn't for us, and
Okay. Do you have offices at the property?
no,
Okay, so you don't have your landscaping contracting offices at that
No.
building? So how's the second floor used, the mezzanine that you, according to
Storage.
the plans? Okay. For storage of what?
I mean, there's furniture up there, there's some, you know, places, you know, the guys wanna come back and hang out for a little bit.
So it's not landscaping storage, you mean it's,
No, it's,
okay,
there's no walls, there's no nothing up there.
okay, all right, thank you.
Okay, does anyone else have any questions for the petitioner? Stephanie Stowe.
Thank you, Mr. Chair. So regarding the way people get in and out, it does look like there's the only one-way arrow on Phillips Court, so that's the intention, is people get in that way, and then how do they get out?
And they funnel out onto Ferry Street.
And is there signage that indicates that?
The market put up a one-way sign at the front, and at the back, there's a red sign that I believe says exit to Ferry Street. So if you're going down that roadway there, Phillips Court, right in front of you, there's a sign that points you to the other direction to exit to Ferry Street.
Okay. I have some other questions.
Okay, go ahead.
So it looks like in the prior permit, there was the obligation to install and maintain privacy fencing, install cameras and lighting. So were those done?
Yes. I have cameras on the buildings. I had talked to the counselor at the time, and he was gonna set up a meeting with the police chief, and I have one camera that's facing towards Route 60 or the bike path. And on that building, I think there's probably 8 cameras outside, plus whatever the tenant has.
Okay. Thank you.
You all set? Thanks. Quick question. When you go down Phillips Court and make the left, and I saw the sign there that said exit Ferry Street, I saw 6 or 7 cars parked along there. Who owns that land that you have them exiting?
The MBTA.
Okay, so that's MBTA land that do you have an agreement with the MBTA?
On my side, I have an agreement, U-Haul has an agreement, and the restaurant has an agreement.
So 3 separate agreements with the MBTA to
Correct.
use that as an easement.
Yeah, and there's an easement that goes right down from the 2 gates that we have at the bottom there, all the way out to Ferry Street.
Okay, and another question, and you may not know this, so that's fine if you don't. Do you know who those 6 or 7 cars are? What business they're associated with?
Not.
Okay, no, I was just curious if you happen to know, because it starts sort of right at where your landscaping property is, and then it goes down that way. And I'm assuming it isn't U-Haul, because I noticed that the bituminous tar is a different color than what U-Haul has. So I'm assuming if they owned it, they would have paved everything and not carved out their little niche of it. But okay, I was just curious if that was the restaurant or you.
I mean, I don't know who actually parks there, but there's like the cutout that goes through to the bike path from Phillips Court in the summertime when we're not accessing that bottom lot. People park there, and, I've never thrown them out.
Okay, but you don't own that, so.
No,
it
that's
doesn't
not
matter.
part of my,
Right, okay. Okay, is there anyone else have any questions? Stephanie, were you all set?
Yes.
Thanks. Michelle, anything else?
Yeah, just one other question. So on site, at the section of your lot that's near the Bike to the Sea, what's in all the storage containers? There's probably, I think when I was out there this morning, I took pictures, looks like there's at least 4, maybe more.
Salt.
Salt's in those containers?
yes. And
Okay.
actually, we're getting rid of the 2 long ones because we didn't have much snow last year. So we've emptied those out already and we're getting rid of them.
Okay. Okay, thank you.
Okay, if no one else has any questions for the petitioner, do you guys have anything else you'd like to add?
Just very briefly, Chairman, with respect to this traffic pattern issue that's arisen, I'd just like to point out to the board that Mr. Gottschalk's employees understand the correct way the traffic is supposed to flow on the light. We will certainly make effort to make sure that the tenant understands that his employees and customers, to the greatest extent possible, should be made aware of a particular traffic pattern that is permitted on that site. But it does seem that there are some vehicles completely unrelated to either of these 2 businesses that are using Phillips Court in a way that may be convenient for them at the moment, but doesn't comply with the special permit requirements. We could suggest additional signing as a further condition to the extent that might help, but I'd like the board to understand that it's an open roadway, and people are going to use a road or a street, and the average car operator may not know or care about the direction of traffic if it's more convenient to exit out onto Ferry Street. I just want to make sure the board understands it's not Mr. Godstock's employees at all. We don't believe it's a large fraction of the people that patronize the used car dealership, but there's another business there. There's a convenience store business and a restaurant, and as everyone knows, people will drive in directions, especially if they think they're on private property or a parking area as opposed to a public way. And if there's an arrow that says go one way, it isn't always the thing that's most honored by the person driving. We are happy to do what we can, and we're happy to accept any additional conditions the board might place if it's inclined to grant the special permit to try to address that issue, but some of that is just out of the control of the petitioner and even the proposed tenant in the property. And I'd also like to state for the record that, because I didn't in my initial presentation, that we have reviewed the conditions that were proposed in Planner Romero's recommendation, and all of those are acceptable. As Mr. Godstock indicated, he complied with those that were called for under the 2016 permit, especially and specifically the cameras and the lighting. It may very well be that he doesn't need to do anything more, but he'll have to consult with ward councilor and the police department again, and whatever they say they want, he's prepared to do at this point in time.
Right, but he can't pick and choose the conditions he chooses to adhere to.
No.
Because it appears he didn't, the property isn't as built per the plan that was approved, and he's using it for services that he wasn't approved to do. So he needs to comply with all the conditions.
That's understood, Chairman.
Thank you. You said that there was another counselor.
Yes, counsel for the prospective tenant and the prospective
Right,
tenant
and-
himself are here, and have asked to address the board.
Okay, I'd ask it to be brief, because that should be really heard in favor or in opposition.
Understood.
Not as a separate presentation for Mr. Godstock, as I'm viewing him as speaking on behalf of Mr. Godstock, who's the petitioner.
Chairman, if you prefer that we do it that way, that's acceptable. I only want these people to have an opportunity to address the board at some point, whether it's an adjunct to my presentation or as someone speaking when you have called for those in favor of the petition. It doesn't matter to us either way, whichever you prefer.
Okay, I'm thinking that they should speak in favor.
Fine.
During the in favor portion, if you wouldn't mind communicating that
Sure.
to them, that would be great.
Sure.
Which will be in a moment if
Yeah.
you're finished with your presentation.
Thank you. Yes.
Okay, thank you, sir. Okay, at this time, I'd like to ask anyone who'd like to speak in favor of this petition. Sir, if you want to come up and speak now, you're more than welcome to as someone in favor. And if you could give your name and address for the record, please, and sign the clipboard.
Thank you very much. Good evening. My name's Charles Glyman. I'm an attorney at Foster, Walker, and DeMarco. I live at 10 Woodville Terrace, Malden. We represent the tenant, AGM Auto Sales Incorporated, and I have a letter that I'd just like to read in support,
Yep,
and
that's
then I
fine.
also have copies. I have copies if anybody on the board would like a copy.
Okay,
of the
you can
letter
read
as
it.
well, but I'd like to read it into the
Thank you.
record if you don't mind. Thank
Yep.
you. So we represent the tenant, AGM Auto Sales, Inc., and of the subject property at 160 Eastern Avenue. We write to you concerning the above referenced application, special permit application number COO06072-2023. As detailed, we request that you vote to allow the amendment of the special permit. Should this special permit application be denied, our client, the tenant at the property, AGM, will suffer extreme financial loss as a result. This property is zoned under the classification of central business. It consists of 25,666 square feet. Property was issued a special permit on July 13th, 2016 on case number 16-10. 17 of the Malden Planning Board. As part of that permit, it was acknowledged that the owner was leasing a portion of the property to Malden Auto Brokers for storage of 35 vehicles as allowed by City Council Paper 204/2016. In 2018, the permission to park was changed to a new Class 2 license for Gary's Auto Sales for 18 cars at 160 Eastern Avenue. This was a new license passed on September 25th, 2018 as paper 327-18. Simultaneously, AGM had a Class 2 for the property at 135 Eastern Avenue and had received renewals over the years without issue. In 2020, AGM received a Class 2 for the property at 160 Eastern Avenue under paper 414-20. AGM then filed its change of address from 135 Eastern Avenue to 160 Eastern Avenue on January 7th, 2021 with the Secretary of State. In 2021, AGM filed for a renewal of its Class 2 for 160 Eastern Avenue and for outdoor parking for 135 Eastern Avenue. Both requests were granted. AGM received a renewal for its Class 2 at 160 Eastern Avenue in 2022 as well. For the original special permit, while the original special permit was only for storage and a restriction existed for sales and offices, that restriction was inadvertently dropped by the subsequent action of the council in 2018. Our client purchased the business without knowledge that the restriction existed, made the appropriate applications, received approval, and only then moved his base of operations to 160 Eastern Avenue. Since then, he has been operating without issue, as he had for years previously at 135 Eastern Avenue. At no time in the past years have there been any issues with his use. The oversight on the zoning amendment was only discovered while our client sought to install new signage at the beginning of this year. The sign company he retained neglected to file the appropriate permits, and the discovery came when the signs were improperly installed. The proposed amendment would address this oversight, but would cause no practical change from the use currently existing on the site. So this parcel sits in the Central Business Zoning District as defined under MMC Section 12-08010F. CB District's use are set forth in the table at MMC 12-12-030. The current petition seeks to amend the previously issued special permit to address the zoning issue in conflict between the special permit issued by the Planning Board and the Class 2 license issued by the City Council. In order to amend the special permit under MMC Section 12-2810E, the applicant must demonstrate that the said reconstruction, extension, structural change, or alteration is not more detrimental to the neighborhood. Based on the historical use by the prior business owner and by our client, this condition is easily satisfied. At no time has the existence of the business at 160 Eastern Avenue caused detriment to the neighborhood. The issuance of a Class 2 dealer license is controlled by MMC Section 608-100 in order to obtain a Class 2 license. An applicant must meet several conditions of the code. Among said conditions, the applicant must demonstrate that the business is conducted at a location that satisfies all applicable requirements in the city's zoning ordinance. In issuing the license and the subsequent renewals, the City Council believed that the site of AGM's business met the requirements of zoning. In conclusion, the approval of the amendment to the special permit will not be detrimental to the neighborhood, while the denial will be significantly harmful to AGM. Considering the weight of the issues presented, it is appropriate that the Planning Board approve the requested amendment. For the reasons set forth herein, I request that the Planning Board grant the requested amendment. Thank you.
Thank you very much, sir. After you sign in, you're certainly, you can bring up the copies of the letters, and we'll distribute it to the board members.
Our client, Marcus Serino, is also here as well, if you'd like to ask him any questions, the owner of AGM.
No,
No
we're
questions.
all set. No, we're all set with that. And if he wants to speak in favor, he's certainly welcome to.
Okay.
Thank you.
Thank you. Can I approach?
Yeah, did you sign in already?
No.
Thank you very much. Thank you. While he's passing those out, if there's anyone else that would like to speak in favor of this petition, you can certainly come up and give your name and address for the record and give your testimony. Thank you very much. Is there anyone else that would like to speak in favor? Michelle, Diane, do you have anything to read in favor? I do not. Last call, anyone else that would like to speak in favor? Seeing and hearing none, declare that part of the hearing closed. If there's anyone that would like to speak in opposition to this petition, anyone in opposition? Diane, do you have anything to read in opposition? Michelle, do you, hold on a second. Last call, anyone speaking in opposition? Seeing and hearing none, declare that part of the hearing closed. Michelle, do you have anything to read in general?
No.
Okay, nothing in general. Okay, very good. Then I'd like to ask you, Michelle, if you could take us through the staff report.
This is the planning report and recommendation dated December 13th, 2023. I will not read it verbatim into the record, but it's incorporated herein by reference into the record. And we heard about the location of the property. There is a single-story building with a mezzanine level, so there's a 6,000 square foot footprint. There are accessory structures used by a landscaping business. We heard about the used car dealer that's on site. As the petitioner stated, it did come to the city's attention through illegal installation of signage on the property. Heard about the petition. You have a copy of case number 16-17, which is a special permit you granted in 2016, which allowed the extension of a non-conforming use. The building construction contracting use is not allowed in the central business zoning district, and also allowed the construction of a new non-conforming building and the accessory structures. The plans are referenced here. I will note, though, for the record, you did receive a revised site plan, so that item number 1 should be with a revised date 12/12/23. The floor plans, exterior elevations. Attached to the decision is also a copy of the site plan that was approved with that special permit in 2016, so you can see what is different and what has changed. As the chair noted, the storage bins aren't exactly in the location, and the existing storage containers, as I said, there were probably 4, maybe 6, which the petitioner said he was going to remove. Those aren't shown on the plan, but those are located in that northern section of the lot. If you look at the pictures, you can see them where they're located. So they're between the Bite to the Sea and the property line. So a portion of the right-of-way is used by the Bite to the Sea, and a portion is used by petitioner. The property is located in the central business zoning district. Building construction contracting use is prohibited in this district. It is a pre-existing non-conforming use. It was legalized by the special permit you granted in case 16-17. Off-site parking facility is allowed by right in this district. That is what the property was being used for when you issued the special permit. It was an off-site parking facility for the auto sales across the street. Now we heard and see that it's being used for retail sales, less than 5,000 square feet of gross floor area. That is allowed by right in this district. As the petitioner noted, when the special permit was granted, that southern portion of the lot was used as an open-air parking lot. leased to another car dealer. There was a outdoor parking license, so that's not the same as the secondhand dealer's license. This is an outdoor parking license. Again, that license restricted use for storage only, prohibited advertising, showing, or sales of vehicles at the property. Beginning in 2017 through the current permit, that restriction was removed from the outdoor parking license. And then, as I mentioned earlier, since 2018, the council began issuing another license, another type of license, which is the used car dealer's license, Class 2, for the business at the property. And as noted, the first license and for the first few years was issued to the petitioner and property owner.
Michelle, sorry to interrupt you, but,
Yes.
so in 2018, it was approved for 18 cars? Do we know how many cars?
Yes, I have the licenses, so let me check. So there's two different licenses. There's the outdoor parking license,
Right,
and
that
then
was
there's.
35.
Right, but then that also changed, so hold on, if you could, please. Okay. So this is the used car dealer's license. Let me get to that other one first. Okay. So, the outdoor parking license, when we heard this case, it was 18. In 2018, it was 18. In 2020, it was 24. 2021, it was 24, 2022, 2023. So it went from 18 to 24 over those years.
Okay,
And then, again, beginning in 2018, they issued another type of license, which was the used car dealer's license. And as I stated, it was first issued to the petitioner for 18 cars. In 2020, also for 18 cars. So to the petitioner in 2020 for 18. Then to this tenant in 2020, it was transferred for 18. In 2021, it went up to 24 cars. And then 2022, it's 24 cars.
thank you.
Yeah. So the direct abutter to the south, to the north is the MBT right-of-way, a portion of which is used by the petitioner for the landscaping business, and a portion of which is used as the multimodal recreational trail by To the Sea Path Northern Strand Community Trail. To the east is a restaurant. To the east is a restaurant and a multifamily residential dwelling with 86 units, 6 stories. That was by special permit. To the west, on the other side of Phillips Court, retail services business, mixed-use property occupied for, at the time, it was petitioner's landscaping, offices, retail services, and retail sales on the first floor, and 6 residential dwelling units on the second floor. All that was by special permit, as well as the, there was the most recent special permit had to do with the freezer trailer added. Into the south, on the other side of Eastern Avenue, a motor vehicle repair shop and automotive sales business. Surrounding land use is a business, residential, and Malden High School. For building construction contracting use, which is what the landscaping use is considered, the building and accessory structures do not conform to current dimensional controls. The principal building violates the western side yard setback and the accessory structures, the eastern side yard setback and rear yard setback. And the nonconformities were allowed by the special permit this board granted in case 16-17. Most dimensional controls are applicable to the proposed retail sales use because the use is allowed in the central business zoning district. The proposal creates new violations. So the proposed addition or use of the property for retail sales would create no new violations. In terms of parking requirements, the building construction contracting use I had written requires 8 spaces, but that was based on occupancy of 6,000, which is not correct. So just let me quickly look at that. So it is 6,000 Well, the mezzanine would be 1,200 as well, so it is still 6,000. So 6,000 times 1.2 is 7, so 7 parking spaces. Because they occupy 4,800 square feet on the first floor, and then he's occupying the 1,200 square feet on the second floor in the mezzanine. The mezzanine's the same 1,200 square feet, I believe. Parking for the landscape contractor, there are, as depicted on the site plan, 5 parking lanes, approximately 10 feet in width, 100 feet in length, located along the northern side of the building. Access is through a gate 22 feet in width via Phillips Court, a private way off Eastern Avenue. Parking for the retail sale of vehicles, as depicted on the site plan, there are 24 spaces located in the southern and eastern sides of the lot, all configured as head-on. The access aisles are non-conforming width. There's access via Eastern Avenue and also via Phillips Court. I will note, and I think the chair brought this up, what's shown on the site, or what's existing on the site isn't what's shown on the plan. I know there were also 2 other parking spaces lined right in the driveway. When I was there today, they were numbered in line. They're faded, but I'm not sure if when the gates close, that's used. That's the Eastern Ave gate. The snow storage proposed for the 24 spaces is located in the northern corner of the property in the area used by the landscaping business. So the finding you need to make to grant a special permit is that, or to amend the special permit, would be that the proposal is not more detrimental to the neighborhood. You want me to move on?
Please.
Prior to the public hearing, provided that the board makes that required finding, the recommendation is that the special permit granted in case 16-17 be amended to allow retail sales of vehicles and a special permit be granted. So a new special permit will issue, subject to the following conditions. 1, install and maintain pavement parkings to delineate parking lanes as per plan. 2, the location of the storage bins may be changed. However, no storage bin may be located less than 5 feet from the eastern property line abutting 180 Eastern Avenue. That's the multifamily building. 3, install and maintain privacy fencing along northern and eastern property lines. 4, install cameras and lighting in locations along Northern Strand Community Trail, bike to the sea path abutting the property to be determined by the Ward City Council and Malden Police. Maintain cleanliness of that portion of the trail path abutting the property, including but not limited to litter control and removal of overgrown vegetation. 5, trash storage, including pickup and screening, must comply with Board of Health regulations. 6, snow storage for the retail sales of vehicles shall be on site. I will recommend condition 7. Retail sales of vehicles may be allowed, subject to city license regulations, and shall be limited to only the southern portion of the lot and 1,200 square feet of office space on the first floor as per plan.
Michelle, you don't think we should define a number?
The issue with the number is 2 things. You can define the number. I'm not sure, the plan that they're showing is non-conforming. So if you approve this plan with 24, it is non-conforming. What I was going to suggest is if you want to put a number in, you should see a plan that shows all the conforming requirements. I do know from the building commissioner that the city council is moving forward to try to ensure and put some new rules and regs on the books potentially that will ensure all the retail sales businesses have to conform with the zoning. So in terms of the parking layout, it can't just be, it's for display, so they don't need to meet the parking requirements in terms of aisle width and size and things like that. So I think that is the direction they're moving in. So it would be advisable, if you're going to put a number in, that you see a plan that tells you what number the site will accommodate, meeting all the dimensional controls, or parking requirements. So aisle width, and it should be 24 feet. So it's showing there's only 19 feet here. It's 20 feet on this side. So it's showing all nonconformities. So if you grant the special permit with this plan, you'll be legalizing these nonconformities. I'm not sure if that's going to be an issue when they go back for license renewals or not. But if you want to put a number in, then I would also suggest that you obtain a plan that conforms to the zoning requirements. The layout, the parking layout.
Okay, I'm just looking to avoid is there seems to be a fluidity to the number of vehicles that, and the number of spaces. I mean, I
Yes.
counted 30 when I was down there this morning, this afternoon.
Yes.
And I wouldn't want to see the council approve something for more than they can accommodate.
Yeah, the 18 that were shown on the approved plan with the last special permit, it limited to the southern side. Now, this area, and if this is the last page of the decision, the area shown on this plan is now occupying a portion of the eastern side as well. So I believe that's where they're getting the additional parking. So previously, it was south of the building, so that was where the lot was. The petitioner was gonna have material storage bins in the section that's now being used for 6 additional parking spaces. So,
So you're recommending they be allowed to do it both in the southerly and easterly sides of the lot? Is that what you read? was trying to
I
write
read
it down.
that, I read as per plan, but then, as I said, I was gonna say, you know, make sure the board was aware of, this is the plan you would be approving. If you don't think this plan works, you should request a plan that conforms
Okay,
with the zoning. And that's specific to aisle width and things like that. Aisles are, you know, to allow proper turning and maneuverability.
okay. Were there any other conditions you were recommending?
That is it. I don't, the Phillips Court, I think, is an issue, but it is, you know, it's not privately owned, and as we went through this on that last hearing, it's limited what enforcement and regulations we can put in. It sounds like they're putting regs or, you know, striping it and putting signage in. There were pictures of that sign, by the way, on the last page. It says, you know, exit for Ferry Street. Somebody hand-painted a sign and put it up on the Bike to the Sea fence, showing. I don't know who's legalized or allowed that, but that's the traffic pattern, I guess, they're trying to institute on their own, but I don't think there's any way we can enforce anything
Okay,
on
thank
that.
you.
So I wouldn't recommend anything with that, unless, yeah, you want to send them to the Traffic Commission.
Okay. Are you all set, Michelle?
Yes.
Ken Antonucci.
Michelle, you mentioned something just now, and whether it comes from the city, the licensing board or whatever, you mentioned a difference between parking and all the, you know, requirements and something used for display. There is no such thing
There
as
is no such,
display.
there is no such difference, but over the years, it's been interpreted that way. We've seen cases where there's auto sales and they say it's just for display, so they propose a non-conforming layout and, you know, because they're parked. This is, there was, I would agree with the chair, there's a lot of activity on this site. There was this morning when I was
Yeah,
there.
most lots, most
Yeah.
used car lots are jam-packed with cars.
Yeah.
And who, I mean, I'm just wondering, does the licensing board review that
They
portion?
they
Because
review-
the license is, they grant a license for a certain number of vehicles.
And they require a site plan be submitted. The new rules and regs that I'm talking about, that I was informed of the building commissioner who's here, if you have any questions, they want to, you know, make sure all the rules, everybody's following all the same rules. So I understand they are gonna start to require professionally prepared site plans that conform to all zoning for their licenses. So it won't be able, you know, they won't be able to say, oh, it's just for display, we don't meet the zoning, but it's okay.
But as
which
of
is-
right now, that doesn't exist.
As of right now, I don't believe it exists. I think they're moving in that direction because of the issues that's my understanding. They're trying to, you know,
If, and I know this, you probably don't have the answer to this, maybe the building commissioner does, but if they did develop an ordinance or a requirement for, you know, to mandate that all the parking, all the display parking matches regular parking requirements, would all these existing places be grandfathered in?
I would ask the building commissioner, Nelson Miller, he's here. If, I don't have that.
Mr. Miller, do you mind coming up and clarifying this point, if you could? Thank you.
Good evening. So there's been a contradiction over the years between our Class 2 licensing regulations and our zoning regulations, although they actually refer to each other. So I've been working with the licensing committee through the city council to kind of bring all those regulations together into one thing, which complies with our zoning. Most of our Class 2 license locations don't comply with these rules. We have a lot of locations that have 10 legal spots, they have a license for 18 cars, and they have 35 cars on site, which causes a lot of issues for the neighbors in the neighborhoods. What the council has agreed to do is that this coming year, these licenses renew every January 1st. This coming year, every Class 2 licensed location will be required to submit a brand-new site plan. I provided regulations to the city clerk that she's going to send out to all of these Class 2 licenses, which mimic our zoning regulations as far as parking goes. Michelle already referenced what those rules are. Size of the parking space, aisle width, snow storage, et cetera. So all these locations will be required to submit a plan which complies with those rules. And what that means is some of these lots, which maybe had a license in the past for 15 cars, may now get a license for 8 cars. They won't be limited to that 15 cars plus 3 for employees. It'll be whatever the lot actually supports in compliance with our zoning regulations. So to your point, Chairman, as far as setting a limit for this particular petition, you certainly could do that, but I think the license could eventually end up changing that.
And that's what I'm trying to avoid, so that we're holding them to one standard, and then this new way of measuring that you're going to be implementing in 2024 is creating conflict. So I think at best we don't identify what the number should be and rely on the fact that this new rule change will capture that and will require them to provide, hold on one second, it will provide the right number that lot can handle.
Exactly. So I think tonight you as a group will be deciding whether or not that particular use is allowed. And then in the future, if you do decide to allow it, the licensing committee will then decide how many spots they're allowed to have on site by compliance with our parking regulations.
Okay, yeah, no, that sounds good. Oh, Ken, did you have
Yeah,
something
no,
you
I
were
just-
looking for? Something?
Yeah, I just wanted, so it won't, the new reg is gonna dictate the number of cars. Previous ones won't be grandfathered in.
Correct.
Right, that's all.
Yes.
Thank you.
And one last thing, Stephanie Stone had a question, which I'm not sure if it should be addressed by you. If it's not, thank you for stepping up.
Okay.
Stephanie?
Thank you. So Phillips Court currently isn't a private way, it is a city?
It's a private way.
Oh, it is a private, oh, okay. But it's not officially designated as a one-way? I don't see any signs, like official city signs that say one-way?
There's no official city sign, and the petitioner or somebody in the group painted the one-way and put up the sign. There's a sign shown on the fence.
Right.
But the city's not regulating that as a one-way.
Right. But if the owners that abut Phillips Court wanted to have an official city sign, they would have to go to the traffic commission to do that.
They would have to go through the traffic commission for signage, yes.
And it does seem like they generally want that, and it would help the flow in the area that's very congested. And that potentially just the painting on the street is not working.
Yeah, it doesn't appear to be.
Yeah. So I would suggest putting that provision in to go to the traffic commission.
To petition the traffic commission for designation of one-way.
Yeah.
Yeah, I mean, I can certainly, you could add that. I think what the issue's gonna be, the city's gonna need to be assured people really do have a right to travel over that MBTA right away to get out. Because otherwise, it's a one-way dead end, right?
Right.
But, okay, I wrote that down. I have one other question, if I could clarify for Mr. Yes.
with Mr.
Nelson,
Miller?
yes.
Yes.
So if the condition were to read, my concern is, if it says as per plan, so I think what we're going in is we don't necessarily want to approve this plan because this plan may change. This plan doesn't conform to zoning, we know it doesn't.
Right.
So it doesn't make any sense to say as per plan. Maybe it needs to say as per plan, approved by, or subject, as per plan, in accord, or that complies with city license regulations. So if those license regulations change, this plan will change. My concern, though, with not saying anything about the location is, if you're allowing retail sales, we want to make sure we know where the retail sales are going. So I think they should stay on the southern side of the lot. It should never all of a sudden be on the other side of the lot, unless the board doesn't see an issue with that. I think there may be an issue with the landscaping business. So I think we should somehow try to designate the location on the lot without approving the plan per se.
Yeah, if I could add to that, I think what you may want to have is some kind of wording which states that what you're legalizing is retail sales specific to a Class II license, and then tie the parking layout to the regulations set forth by the Class II license. So that if for some reason the Class II license goes away, then it doesn't suddenly become a retail sales storefront with no parking, with no parking plan. So they would be restricted to the retail sales use as a Class II license, which then carries along with it its own parking regulations to be established by the city council. That will also protect against the fact that there's a new licensing committee coming in January, I would presume, with a new city council, and, you know, things get dropped off agendas and changed and whatever. So we're counting on these rules changing, but we don't know that until they actually do.
Okay, thank you very much. Michelle, did you get that?
Yeah, I'm saying retail sales may be allowed and is restricted to vehicles per Class II license. Then I have parking layout per city license regulations. And then, I think we should state, parking location must be in the southern portion of the lot. I think we need to state that.
And that would eliminate the easterly portion of the lot. Hold on a second, Ken.
I don't, it's up to the board if you want to say southern and southeastern portion of the lot. That's what's being shown to you, so
Okay,
if
why
you're
don't you
okay
put
with
that
that,
in
shall be southern and
right.
shall be limited to southern and southeastern portion of the lot, and 1,200 square feet office only on first floor.
Okay,
Okay,
so you got that? Stephanie, were you all set?
Yeah, so the little street at the back is not an actual street, it's
No.
a,
what's shown in this picture, when you turn the corner, and this is the top picture, that is the MBTA right-of-way. So cars are parked along the right-of-way, and that is being used as an exit road.
what cart, do we know?
I don't know, there's a series of cars that are parked there.
And
In this
petitioner said they
picture.
weren't his and he didn't know who they were.
Okay, yeah.
I don't know who's parking there, but yes, I mean, as the chair said, you can even see in the picture, the pavement changes. If the MBTA says you can't use that, then, you know, you could, that could be a problem. And as the chair said, this wasn't this way when we saw this last. So that was the condition 7, then condition 8. I had petition, and this was, if this is what you want to do, petition Traffic Commission to designate Phillips Court as one-way.
In private way, I don't know that we can. We're going to run into the same problems we ran into with
Russell,
Russell Court.
yeah.
So so I'm not sure that we can do anything. But Stephanie suggested it be put in.
Right, if they ask and if it's feasible to do, if the traffic commission can do it.
Right, I just don't know if they
Yeah.
can. Because I know we had resistance with Russell, on what could be done with Russell Court in
Right.
limiting that.
I just don't want to put in a condition that
Right.
these guys are not going to be able to comply with, that it's out of their control, you know? I mean, I think if we feel good that the traffic commission is going to be able to respond to it, and,
I don't think we could, I don't know that we're gonna be able to. We weren't able to on Russell Court, so.
right? But I think Counselor made the comment that they would be willing to add signage on their own to sort of help mitigate some of that issue, so
Yeah.
maybe the condition is just to add some additional signage as opposed to having the traffic commission do it.
No, I understand where you're going with it, Pat. So keep that in mind for whoever's going to make the motion, whether we ask them to go to the traffic commission or whether we just require additional signage. Are you all set, Stephanie?
Yep.
Eric Henry.
Yes, thank you, Mr. Chair. Just maybe for Mr. Miller, you may know, so we're spending a lot of resources discussing about parking and things of this nature. So who's tasked with the compliance portion of this? Who enforces this?
It's a combination. Myself and my staff can enforce these regulations as well as the compliance officers who are not my staff. They actually report to the city council. So the Class 2 license, anything that's issued by any license issued by the city can be enforced by the compliance officers. Any zoning regulation obviously falls under my purview. So there's a lot of things that kind of overlap.
And what does penalties look like for this?
Zoning penalties are $300 daily.
Thank you. With regards to the signage and the traffic, I personally, I live on a private way, and I know several years ago, we petitioned the traffic commission to make our street a one-way street, and it was approved, and it lasted for about just as long as other neighbors could figure out, and got the city councilor to come, and he took down the sign. So, and just usurped all of but anywho, my point is that I would recommend that we probably do put it in there and let them tell us no, as opposed to us, we telling ourselves no.
So you're suggesting what?
I'm suggesting that we do make the recommendation that we send it to traffic
To
commission.
traffic commission and signage, or signage? And I'm not sure, because you had said the signage.
I didn't know there
sounded
was,
good.
I'm not sure there was a difference, but I would be in support of any petition, any a recommendation that would include it going to the traffic commission with regards to the signage, making it a one-way, and allow, that's their purview, so allow them to tell us yes or no.
Okay. When you make a recommendation, or whoever makes a recommendation would need to articulate that.
So you're saying petition to the traffic commission to designate Phillips Court as one-way. So if they do designate it, the city would put up the signs and the markings. The other option, though, is if they don't, I thought the other option was that the petitioner would install his own signs.
That was the other option.
Okay, okay, but we still would, okay,
That-
I
that's
wrote
why
both
didn't
of those.
understand the support
Okay.
for the adding the signage and also going to
Okay,
traffic.
so there's
That's
two
why I just wanna
types of
clarify
signage, right,
with
okay.
Eric.
Thank you, I yield.
Okay, Ken Antonucci.
Can we ask traffic commission to determine whether or not they can, I mean, I just don't want to hold the petitioner to something like what Pat was saying, that they can't possibly enforce, I mean, you know, the first option was to, you know, propose it go before traffic commission.
Yeah, to file a petition. So all they're required to do is file the petition. We can't put the condition in that the traffic commission does anything.
Right.
The condition would be, petition or file a petition with the traffic commission seeking to designate.
And
So
do all-
if they end up saying no, he still complied as long as he filed the petition.
And then all of the, I mean, I don't know the traffic commission's rules or whatever, but I know the MBTA right away creates issues from other properties. I don't know, I lost my train of what I was gonna say there, but the, I don't know, I'll have to rethink what we were talking about here.
Ken, do you have anything more for Mr. Miller?
No, thank you.
Thank you, Mr. Miller, I
Commissioner.
appreciate it. Okay, are there any other comments or questions? No comments or questions? Then is there a motion? And when you make your motion, please articulate this idea of going to traffic commission or looking for the petitioner to put up signage. Ken Antonucci, go ahead.
Yeah, Mr. Chairman, I'd like to make a motion to grant the special permit, subject to the 8 conditions listed, and the 8th condition itself be the petitioner petition the traffic commission to determine if it can, this Phillips Court can become deemed a one-way. Sorry, it's not as eloquent as I'd like.
Do you have that, Michelle? Is there anything you need clarified?
So grant special permit subject to 8 conditions. I want to just clarify for the record, condition 7 was what I read regarding retail sales may be allowed and is restricted to, and then they had the 4 criteria. Vehicles per Class 2 license, parking layout per city license regs, location of parking shall be southern and or southeastern portion of the lot, and 1,200 square feet of office only on first floor. So those are the 4 restrictions.
Yes,
And
that's,
then 8, petition to traffic commission to designate Phillips Court as one-way.
yes.
Okay, is there a second for Ken's motion?
I'll second.
Stephanie Stone has seconded it. Okay, give me a second here. So we got Ken. Okay, go ahead.
Ken Antonucci?
Yes,
Diane Shuha?
Yes.
Tawadej Gebrselassie?
Yes.
Risa Gray?
Yes.
Patrick Hayes?
Yes.
Eric Henry?
Yes.
Eric McCush?
Yes.
Stephanie Stone?
Yes.
Chuck Ioben?
Yes. Petition's been granted with conditions. Counselor, I suggest you walk your client through them so that he's aware of what he can and can't do there and what the next steps are, because you do have, as one of the conditions, petition traffic commission about making that portion of Phillips Court one-way. Okay? Thank you very much.
your nameplate. Thank you.
See you later. Thank you. I'll try to talk to you before Christmas. Yeah. Thank you. You all set, Michelle?
Yes.
Okay, the next item on the agenda is 0 Broadway, also known as 235 Broadway. Diane, could you read the notice?
The Malden Planning Board will hold a public hearing in the Herbert L. Jackson Council Chamber, Malden City Hall, 215 Pleasant Street, Malden, Mass., at 7 p.m. on Wednesday, December 13th, 2023, tabled on November 8th, 2023, and September 13th, 2023, on the petition of Massachusetts Electric Company, doing business as National Grid, permit application number CMID 056676-2023, seeking a special permit under Title 12, Chapter 28, Section 090 of the Code of the City of Malden to allow a utilities facility and substation structure, namely to construct a new control house containing 2,232 square feet and to install and/or replace various substation-related equipment at the property known as and numbered 0 Broadway and also known as 235 Broadway, and by city's assessors parcel ID number 153501102.
Just writing that down for you. Thank you very much, Diane, and I will announce for the record that member Risa Gray and member Ken Antonucci left at 8:28 p.m. They were not here for the original hearing of the petition, so they are not allowed to participate in the taking it off the table. Okay, so Michelle, can you give us an update?
Yes. So you have, I prepared a supplement, it's called Supplement 2, it's dated December 13, 2023. And this supplements the planning report and recommendation supplement dated November 8th, 2023, and the planning report and recommendation dated September 13, 2023. You should have not only the new information, but the information that was submitted in November, as well as the original package, because you've had two hearings on this so far. So procedurally, I will just bring you up to speed. On September 13, 2023, the board held a public hearing and tabled a public hearing and its decision to allow the petitioner to address various requests. Those are described in the November supplement. On November 8, 2023, you reopened and held the public hearing, received responses to the previous requests, and then tabled your decision to obtain the following. 1, more information from the city solicitor regarding risks to the city of allowing the encroachments to continue, a list of potential risks and liability. 2, city solicitor's opinion regarding petitioner's proposed language for a special permit condition regarding encroachments. Petitioner had proposed a condition at the public hearing in November. 3, the city solicitor suggested language for the condition regarding encroachments and guidance on language that would be agreeable to the city petitioner. And 4, the city solicitor's thoughts on the question: if both parties agree to the encroachment, why is it an issue for the city or planning board? So you have received, or we have received this following new and additional information. You have a correspondence dated December 13th from Joshua Lee Smith, Bowditch and Dewey LLP, Worcester, regarding update concerning encroachments by Massachusetts Electric Company, application for special permit for upgrades to existing electric substation and other related improvements, site improvements on 0 Broadway, aka 235 Broadway, Malden, Massachusetts. You have a copy of that in your package. You also received, or the city received, proposed language for the condition of the special permit regarding encroachments of the 3 abutting properties: 251, 257 Broadway, 295 Broadway, and 17-23 Coleman Street. The proposed language was agreed to by the city solicitor and petitioner's attorney. It's reflected in recommended condition 5. So that has brought you up to date on where we stand procedurally. You are currently in deliberations. You hadn't tabled the hearing, so you were not going to reopen the hearing. And you're in deliberations to make a decision on the special permit petition. petitioner's attorney and some of his team members, the project manager and others are here if you have questions. If the board has questions, they'll not be making a presentation. You typically don't receive a presentation. The city solicitor, Alicia McNeil, is also here if you have questions.
Okay, the one question I have is, has National Grid complied with the conditions? Have they submitted the agreements with the people that are encroaching?
Yes, as the letter I'll read a portion of the letter, December
if you could.
13th, 2023. It states, this letter confirms the following. The 3 encroachment agreements have been signed or, according to the encroachers, are about to be signed. 251, 257 Broadway by David W. Jackson is co-trustee of Provident Realty Trust. That's the auto body business. That's awaiting signature. Second agreement, 231 Broadway by Playful Paws, Inc., that's the doggy daycare business, is signed. And then the third is 17-23 Coleman Street by David R. Malliott. That's the fence patio encroachment, and that is awaiting signature.
So those are the only 3 encroachments that we have?
That is what yes, that is correct. That is what was shown on the plan, and those were the 3 properties identified. So this condition 5 would apply to those 3. In condition 5, I mean, we will eventually read it, but it basically I'll give you a summary. It basically requires, if there is an encroachment, as of the date of the granting of the special permit, there needs to be an encroachment agreement within 30 days after the date of the special permit. And that has to include certain provisions that indemnify and hold the city harmless. Also included property insurance provisions, include a recording requirement, so that the notice of the encroachment's recorded. And we need to be notified that they're carrying the property insurance. If the encroachment agreement is not signed, basically, property owner will provide written notice informing them that within 90 days of the notice, they must cease and desist use of the encroachment area and vacate it. And then it just goes on to talk about the remedies and other things that they must do to pursue that removal of the encroachment. And again, we're gonna read this. I'm not gonna read it twice unless you want me to.
No,
I'm
just trying to
Those are the main
ascertain.
points, yes.
We asked that the city solicitor come,
Yes.
congratulations, our newly appointed city solicitor. If you want to come up, solicitor, you're welcome to. But I'm just trying to ascertain whether we have met everything. If you want to give us an update, Counselor, that would be welcome, because there were 4 questions that we were being asked, and it generally concerned the risk associated with the property and with the abutters and the reason for the encroachments. Do you feel that you've worked out an agreement with the petitioner?
Yes.
To your satisfaction, so everything, the risks have been communicated so that everyone understands it, the reasons why we need the wording, because at the last hearing, National Grid was adamant that they could not accept anything about the liability and the hold harmless and things of that nature. But you feel you've reached a conclusion at that?
Yes, good evening, Mr. Chairman and members of the Planning Board. Yes, we have had several meetings, and there is a meeting of the mind that the city is satisfied.
Have you had any interaction with the people who are encroaching on the land?
No, I have not personally.
Okay, I was just curious if you had it at all. But to your understanding, everything's all set. As long as they get these agreements signed, then we should be fine, and we're mitigating the risk on behalf of the city.
Yes.
Okay, does anyone have any questions for the solicitor? Michelle, anything?
No.
Thank you very much.
You're welcome, thank you.
appreciate your help with this.
You're quite welcome.
Okay, so fortunately, our legal team has been able to meet with the petitioner and hammer out the problems with regard to the risk that were concerning us, and hopefully that it sounds like that has been resolved. Does anyone else have any other questions for Michelle? If not, is there a motion? Oh, I'm
Mr.
sorry,
Chair, do you
Michelle,
wanna
I'm jumping the
read-
gun.
yeah,
Please
do you
read
wanna
the,
read-
please read
Well,
the
no,
staff report.
just for the record, for the
Yep, no,
public
go ahead,
record.
please read the staff report.
Well, I read most of it. I would recommend these conditions to any special permit granted. 1, all development shall be as per plans except as modified by these conditions. 2, install and maintain fencing 12 feet in height using textured tough barrier, TUF barrier plus style by AIL sound walls or comparable similar style to screen abutting residential properties. That was what we discussed at the last meeting. That's what they showed us and was proposed. That's the description of it. 3, security fencing may be a maximum of 9 feet in height, which includes 1 foot of barbed wire on top. 4, compliance with the requirements of the city engineer as stated in the memorandum dated November 2nd, 2023, which is incorporated herein by reference and attached here too. It will be attached to the decision. And 5, this is the new condition. This special permit authorizes use of the property for only an electric utility substation and shall not be deemed to authorize or approve any other use of or encroachment onto the property. Any encroachment onto the property existing as of the date of the granting of the special permit, for example, structures or fixtures, shall be memorialized in a written agreement between the property owner and the encroaching party, each an encroachment agreement, within 30 days after the date the special permit is filed with the city clerk, shall include provisions that the encroaching party shall indemnify and hold the city harmless from liability that may arise from any injury to or the death of persons or damage to property within the encroachment area, require the encroaching party to maintain property insurance for the encroachment area that includes the city as an additional insured, and require that a notice of such encroachment agreement be recorded in the Middlesex South District Registry of Deeds within such 30-day period. Pursuant to the encroachment agreement, the city is to be notified each year of such required property insurance. If the encroaching party does not sign the encroachment agreement, the property owner shall take all necessary steps to ensure the encroachments are removed, including but not limited to pursuing its appropriate legal remedies. In the event that an encroaching party fails to enter into an encroachment agreement as provided herein within such 30-day period, the property owner shall provide written notice to such encroaching property owner, informing them that within 90 days from the date of such notice, use of the encroachment area must cease and desist, and the encroachment area must be vacated, including the removal of all personal property, structures, improvements, and/or equipment thereon. The property owner shall actively pursue its legal options to enforce its rights to have the encroachments removed, including but not limited to filing a complaint in the appropriate Massachusetts court. As long as the property owner has used reasonable efforts to enter into the encroachment agreements, which reasonable efforts include presenting the agreements to the encroaching parties that desire to remain and actively communicating with such parties as to the status of signing during such 30-day period. So that's what reasonable efforts means. And/or actively pursues its legal remedies to have the encroachments removed. Any building permits necessary for the project will not be withheld, delayed, or suspended. If, after the signing of the encroachment agreements, the encroaching party's insured company refuses to add the city, the property owner shall actively pursue its legal options to enforce its rights to have such encroachment removed as provided herein. The encroachments may remain provided that the encroaching party abides by the applicable encroachment agreement and obtains any and all permits and approvals that are necessary to use the encroachment area and encroachments.
Thank you, Michelle.
Yeah.
Does anyone have any questions for Michelle? If there are no questions, is there a motion? Eric McCush.
Thank you, Mr. Chair. I'd like to make a motion to approve the special permit with the 5 conditions as listed.
Eric's made a motion to approve the petition with the five conditions. Eric Henry.
I move to second that motion.
Thank you. Eric seconded it. So it'll be a roll call. And just for the record, both Stephanie Stone and Ronnie Raj Verma will be participating in the hearing, as they have been all right along. Okay, go ahead.
Diane Shuha,
Yes?
Tawadr Gabrasalasi,
Yes.
Patrick Hayes,
Yes.
Eric Henry,
Yes.
Eric McCush,
Yes.
Stephanie Stone,
Yes.
Ronnie Raj Verma,
Yes.
Chuck Oben.
Yes, petition is granted with conditions. And you got copies of the conditions so you understand what they are? Yes. Very good. Thank you very much. I'd just like to thank Building Commissioner Miller and City Solicitor McNeil. Thank you for coming this evening and helping with the hearings. Okay, next thing, why was that going off like that?
Oh, was that mine?
I'm not sure, I'm shutting them all off, except for Eric Henry. Eric, is there a Community Preservation Committee update?
Well, yes, there is, Mr. Chair. Thank you. Actually, we did vote on 6 petitions that came before us here recently. 5 were granted and 1 was not. The Malden River Works was, and the Oak Grove Association, Community Association, those 2 petitions were granted, and I note those specifically because they're examples of petitions that were community-driven by petitioners, citizens that drove those petitions. And they came in, the Malden River Works was granted for $1 million, and the Oak Grove building to refurbish that, another historic, well, long-term historic building in Malden was granted as well. We also granted $750,000 for the purchase of the land at the Malden Hospital site. They also approved improvements to Fitzgerald Park for a sum of about $175,000, and also Linden Rink project where they're going to improve and put a street hockey rink in the Linden school facility out there was approved as well. The one petition that did fail was to one of the remaining historical buildings in Malden that was commissioned and built that had ties to the Converse families. That's 15 Ferry Street. And unfortunately, that did not get past muster with the CPC. And so unless there are any further questions, that's about it. Oh, one more thing. Those did go to City Council last night, and I think they were all met favorably with City Council's approval.
Terrific. Question, Eric.
Yes, sir.
15 Ferry Street, so what happens now? Or is that not your problem?
It's my problem as a citizen that I think
No, in the capacity of CPC, so there's nothing else? Can they be resubmit next year? I'm just curious how that sits.
It's my understanding that this round is finished, and the property owner by right can can do as he please, and that up to and including destruction of that building. It also, it's gone through all the iterations with the Historical Commission, with the demolition delay and things of this nature. So there was, the only mechanism I think that could have possibly happened would have been to table that motion and send it back to council for further recommendation or remediation. But that was not the motion that was before nor passed the CPC.
Okay, no, I was just curious more than anything, because that's a great building, and,
I have some more info if you're interested.
yeah, I am, if you have anything to share.
Yeah, as the board knows, I'm the clerk to the Historical Commission, and so, as Eric just said, the CPC application was disapproved. They were seeking funding to relocate the building. So that, they're not gonna get the funding to relocate the building. So essentially, they're back to square one, in the sense that they have a building that they'd like to demolish. The city is in the process of determining whether they need to go back through the demolition delay ordinance, because they've been through it once, but the demolition permit was withdrawn. So I personally believe they have to go back through. That's yet to be decided. So the other option that the Historical Commission has requested is that they pursue incorporating the building into their project. There's a proposal for the former 1 Salem Street building site, which is the quote, hole in the ground on the corner of Main and Salem. And Ferry Street sits next to that. So that was the Historical Commission meeting yesterday. That's what was, the attorney for the 15 Ferry was directed to start to re-explore those options. They previously had said they could not incorporate it in. That being said, as I said, it remains to be seen whether they have to go back through the demolition delay ordinance. And the final part of this is our zoning ordinance does require a special permit for any development at that site, special permit by this board. The zoning ordinance also requires that you take into account the recommendations of the Historical Commission in your decision. As we've done on these other projects, American Legion building, you incorporated the recommendations in. For example, a couple of the other ones where they were specific, the one that's on, I just drew a blank, what's the street off of Glenwood, where they rebuilt the 3-family? They had to make it look historically accurate. What is not Greenleaf?
Oh, yeah, Beltran.
No, is it Beltran?
Francis
Street, 47
on the
Francis.
corner of Beltran.
As you recall, their plans went through Historical Commission, then came to you, so when you issued the special permit, you incorporated it in. So we will see what that brings to your table, because again, they will need to seek a special permit to do anything at that site. So
And
that's where it stands.
and thank you for that,
Yeah.
Michelle, as well. I just want to add for the, there was significant public opposition to the fact, not holding on to the building or not wanting to maintain that piece of history in Malden, but it was the location that kind of got some consternation from the, they wanted to move the building across the street and basically on the corner of the high school, across from the fire station, and that's where it kind of went south.
Yeah, that was the proposed location. So if there's another location, that remains to be seen. The petitioner has also, the owner has stated he's tried to sell it for $1 thing. You can have the building for $1, but you have to move it. I don't know where that stands, so, that is one of the 3 remaining Converse buildings in the city, so I think we'll hear more about it.
Well, that's helpful.
I just
Thank
wanted
you.
to add that, because we just heard about it yesterday, actually.
Thank you.
No, that's terrific, thank you.
Fellow CPC members are here and that as well. Thank you.
Very good. Appreciate that, Eric. And the next board meeting is January 10th, 2024. Yes. Okay, so is there anyone that would like to make, if no one else has anything else, is
Mr.
anyone
Chair,
want to make a
I'd like
motion?
a
to
point of
adjourn?
privilege, please.
Yes.
I'd just like to thank everyone and hope that everyone has a happy holidays and look forward to seeing everyone next year. Thank you.
Very good, yes, happy holidays to everyone and Happy New Year.
One other update I just want to give briefly, so you'll know, MBTA community zoning proposal is moving through the zoning amendment process. The council received your recommendation. They did take action last night, and we are still moving forward with that process. So, wanted to give you that brief update.
Chuck, front page of the Advocate.
Oh, and Chuck was on the front page of the Advocate.
Yes. Yes.
Right, but that was
Top
your
fold.
zoning hearing.
Yes.
With your, what was that, your high school picture?
No, that's my,
College, I'm sorry, I meant college.
no, it's my professional one. More recent than either my high school or college, as you can tell by the fact that I have no hair. But if that's it, entertain a motion to adjourn. Diane Chuha, seconded by Ronnie Rajverma. All those in favor say aye. Opposed? Motion carries. Thank you very much.